Thank you very much, Mr McMahon.
If the court pleases, as I know, I appear with Mr O'Brien for the Paramperu Committee. And in Warpri language, that word Paramperu means justice. In making these submissions today, remember that our client seeks from this court especially one thing, as Mr Mullins has raised, which is the truth, and that will guide some of the propositions we deal with today. And I might remind Your Honour, if I may, that on the very first day of this inquest, one of the most senior Warpri elders, Robin Jabananka Granitz, came to the court and said, "We are here to speak the truth. We have always spoken the truth because all we have is our truth. We do not want you to tell us what we need and what we want." Before I address some of the more legal matters, there are two preliminary points that should be made on behalf of our client. The first one has been touched on by Mr Mullins, and that is that for every single day of the inquest, over months and indeed years, and the timing of it was until the last witness left the witness box, which is when the lawn was brought to an end, the collection of on the lawn. Our client sat out there on the lawns, and they did so to remind us all of us, that it's our collective responsibility to get to the truth. And secondly, it must be remembered that by attending and constantly following the inquest, our clients, and of course particularly the families represented by counsel who have already spoken, they repeatedly faced the trauma of the shooting and its aftermath. It wasn't just attending, it wasn't just demanding that we search for the truth. It was doing all of that while repeatedly facing and dealing with the trauma of the events under investigation in this inquest. What we propose to do in these submissions is to identify a number of disputes where we've had a particular interest and been particularly engaged. Obviously, it goes without saying we can't address more than a few. The first matter to briefly mention is scope. In the final report of the Royal Commission to Aboriginal Deaths in Custody, it was said by the commissioners to understand the last hours of life of each individual and to truly understand the circumstances of their deaths. Your Honour will pick up the language in the current Act. Commissioners had to know the whole life of the individuals. Now, the video of the IRT and the police from the IRT and what they did on the 9th of November 2019 in the remote Aboriginal community minutes after arriving up until the time of the shooting. That's only some of the disturbing evidence that this inquest has analysed. A lot more has needed to be analysed and to be unravelled to understand how the circumstance came about. Some of the parties in their submissions have sought to very much limit the scope, but we say that to understand how the circumstances of this killing came about, it includes examining the manner of policing, including community policing in Yuendamu, both generally and at that time. The manner of policing by the IRT, both generally and at that time. And given the constellation of circumstances of this case, it's necessary to examine the attitudes and understandings of all of the principal players who are involved. And indeed, as the inquest unfolded, it became clear that it was necessary to examine the very functioning of a remote community, to understand the interlinkage between the standard of living, the way of living, and how it could be that police could behave as they did on that night moving through the community in the way that they did. And I'll say more about that later. But what it presents this court with is an entire mosaic. And it's that mosaic which, in effect, we say mandates the scope both of the inquiry, of the inquest and its outcome, and where Your Honour goes with findings and recommendations. Through the inquest, the Parnborough Committee has been focused primarily on the future. Our clients live at Yuendamu and will do so. They are the people most concerned with preventing further such deaths. They wish to live in their community harmoniously and safely, including in all their dealings with the police at Yuendamu. And it is with that in mind that these submissions are made and focused. The first issue I'll deal with is guns, and I propose to deal with a number of issues and perhaps juxtapose the positions and show, if I may briefly, where the debate lies. In our cross-examination through the inquest, we explored with numerous witnesses the need for police to wear guns on their hips in Yuendamu. Not everywhere in the Northern Territory, but just in Yuendamu. And we showed through the evidence that there are numerous countries, including countries with remote rural areas comparable to Australia, such as New Zealand or Norway, England, where police routinely do not wear guns on their hips. In the answering submissions from the police force and the police association, 2 points in particular emerged. First was the submission, which might be summarised as saying that the police absolutely need to wear guns on their hips for the reasons set out in those submissions. And second, we say that the submissions reveal a failure, really, to address the realities that police in other comparable places do not wear hip guns. So the dispute is clear enough. At the start of the inquest, Senior Warlpiri Elder Ned Championjimpa Hargraves addressed the inquest and said, "No more guns in our communities. The police must put down their weapons. We cannot walk around in fear in our own homes anymore. We do not want any police officers to live and work in our communities with guns and other lethal weapons." Although one way of looking at this dispute, some might suggest, is to say that the police know best. We reject that analysis. Rather, we say that those who have lived their lives in Yuendamu, who carry leadership responsibility, who remember events over years and decades, events of crime, of policing, of good times and bad, their lived experience is that police carrying guns is not needed or wanted. Other council and many written submissions, including ours especially, I suppose, have set out the long and terrible history of violence against Aboriginal people in the Northern Territory. The effects of colonial brutality remain a constant. And as the events of the 9th of November showed all too clearly, conduct which would cause outrage in other places within Australia can pass for normal when those on the receiving end of that conduct are Aboriginal people. An obvious example is, of course, the deploying of a group of police, commonly called in this inquest through submissions, paramilitary group of police, into a row of homes, carrying a dangerous rifle, an AR-15 military rifle, despite women and kids being everywhere, using threatening language against a woman who speaks up and asks, "What on earth are you doing?" Jumping fences into homes. Now, senior police have said in their evidence, this kind of policing isn't normal policing, it's not community policing, it's not good policing. And as we say, it doesn't happen elsewhere in non-Aboriginal communities. So when someone says, well, the police know best, and they say they know best about carrying guns in community, the community at Yuendamu hears a subtext. And what is that subtext? Part of it is that although from year to decade, no person in Yuendamu shoots a policeman, the answer is, well, one day they might shoot at a policeman. So we, the police, need to continue with our guns in our holsters, need to push down on the community with our guns in our holsters. Our argument, amongst others, is that if the police at Yuendamu on the 9th of November had done their job properly, quietly, respectfully, talking, waiting, there was no need for guns, no need for shooting. And as we've repeatedly said, no one from the Parapuru Committee is arguing against police having guns at the station or locked in vehicle and close at hand. And one of the good things to have come from this inquest is that already in their submissions, the Northern Territory Police Force have said that it may be possible to develop an agreement as to when it would be normal for police to wear firearms in community. So that's a start. And we strongly welcome that possibility, and we urge it as an absolute minimum, as a recommendation to that effect. There are numerous police who over the years have worked and lived at Yuendamu who are held in high regard by that community. And long after this inquest is over, our clients will be there living at Yuendamu every day engaging with the police. It's necessary and essential that that relationship works well. And every recommendation we make has that principle in mind. Another issue where the parties are in stark dispute is the question of using dogs in policing. And as we say in our written submission, there are a few issues in this inquest which throw up quite so starkly the chasm between police and the Aboriginal community as to the use of dogs against humans. And of course, not only were dogs present on the 9th of November, police dog present on the 9th of November, but Kumanjayi Walker himself had previously been hospitalised when, as a youth, and absconding from a youth detention centre, he was chased, tracked down and bitten and hospitalised as a result of a dog attack, police dog attack. So the issue really becomes, are they a useful policing tool or an instrument of oppression? And whatever the theory might be, which is set out in the police submissions, the reality is that the use of dogs in the Northern Territory is heavily weighed against Aboriginal people. It's they who are arrested in such great numbers. And because of that, there is no escaping that using dogs is burdened with racial implications. Youth detention in the jails are overwhelmingly filled with Aboriginal people. But we are narrowing the debate. Our submission is focused only on the use of dogs at Yuendamu. And Your Honour has heard evidence about the fear in that community of police dogs. And so as with the guns debate, it's essential that relationships between the community and the police works well. The evidence is that dogs harm that relationship. And we urge a recommendation that police take the step of not using police dogs in Yuendamu. I'll deal very briefly with militarisation because it's been dealt with so substantially in submissions, but contrary to the position of the police force, we say that the IRT was plainly infected by a military mindset. The military-style weapons, military-style uniforms, the attitudes of IRT revealed in their text, even military-style tactics where the arrest of Kumanjayi was seen as a prospective snatch and grab from Kirstenfeld's evidence. Professor McCulloch has spoken of the international experience of militarised police forces, and our submission shows clear symptoms of that problem. And we urge a finding and recommendation to the effect of steering the police force away from the practices which have led to that conduct. Counsel assisting dealt at some length this morning with lies of Mr. Rolfe. Now, as is already plain from everything I've said so far, much of what we deal with does not concern Mr. Rolfe, and despite Mr. Rolfe's submissions in this inquest, much of what the inquest deals with does not concern Mr. Rolfe. But he is a central police figure in the narrative. His conduct and answers in the inquest have increased his centrality as a figure in the inquest. For a long time, much of the truth about what happened at Yuendamu on the 9th of November was really known only to very few. The trial was run, as most criminal trials are understandably run, on the narrowest of grounds, on the intent and perception of Mr. Rolfe at the time of firing only the second and third shots. And as I've already dealt with briefly on the question of scope, what was not part of the trial but is relevant to the inquest are the broader circumstances surrounding the killing. And one issue that remains very much in dispute is the question of whether Mr. Rolfe has lied on the question of whether Kumanjayi Walker reached for Mr. Rolfe's gun and put his left hand on Mr. Rolfe's gun. And despite what some parties to the inquest say, we say this is a matter which is relevant and important and part of the task of finding out the truth of what happened. The handled gun issue is an alleged fact which occurred prior to the first shot being fired. Indeed, prior to the gun being drawn at all. And it's a matter alleged by Mr. Rolfe, both at trial and here. Now, one reason an analysis of this is particularly relevant is because the character of Kumanjayi Walker has been systematically attacked in some places since the time of the shooting by a variety of interested parties. So if the evidence demonstrates that at a critical moment, central to what Mr. Rolfe says happened, that Mr. Rolfe is indeed lying about what happened and what Kumanjayi Walker did, then that fact should be examined and understood. In our written submissions, we and others have traced what Mr. Rolfe has said about this. A number of parties at the inquest directly put to him, including counsel assisting and Mr. Mullins, that what he said about this was a fabrication. And so far as we're aware, no person who has seen the videos except Mr. Rolfe alone says in this court, in any statement, in any analysis, in any submission, that the video shows Kumanjayi putting his hand on the gun. Only Mr. Rolfe says that. And given that there's considerable evidence from other parts of the inquest to show that Mr. Rolfe is an untruthful witness, the court can find as an absolute minimum that there is no reliable evidence to suggest that Kumanjayi put his hand on the gun, and secondly, that Mr. Rolfe lied about Kumanjayi Walker doing so. And if Your Honour does find those facts, then Kumanjayi Walker and his community, at the very least, deserve a finding to that effect. I'll deal briefly with another issue of dispute which others have covered in some ways today, is the question of the relevance of whether Mr. Rolfe was unlawfully violent in carrying out his duties in the lead up to the 9th of November. And we say it's important because it affects an assessment and an understanding of the shooting on the 9th, and in turn, this impacts on possible findings and recommendations. When we have submitted that the evidence obtained through technology, through the body-worn cameras, text messages, the videos of the computer records, in combination show that Mr. Rolfe was often unnecessarily violent when carrying out his duties, that he was violent against Aboriginal people, that he left a trail of evidence to show that he thought his conduct was humorous. And the evidence regrettably shows that this conduct was done with an attitude of contempt, indeed racist contempt for Aboriginal people. Again, regrettably, taken as a whole, the Northern Territory Police Force has failed in its role of protecting the community from such behaviour. As we've said elsewhere, and we don't hesitate to say again, we do not criticise every officer. We do not at all take an anti-police position. Quite the contrary, as I've already said today, our clients will be living with the police and hopefully working well with them for the rest of their lives in a small community. And we radically acknowledge how impressive and thoughtful numerous police officers have been at the inquest, and no doubt the force has many more such members. And we know from our client the respect that some police have earned at Yuendamu in their service there. But when the videos are viewed collectively, a horrifying picture emerges. We say effectively, with Rolfe lying about what happened at some incidents, but those checking the videos effectively waving his conduct through, others failing to adequately call Rolf or his supervisors to account, or whenever he is called to account, it amounts to effectively no real holding to account. What we see is systemic, ongoing violence against Aboriginal people without meaningful consequences when examined within the Northern Territory Police Force. We say that often conduct which would actually be seen as violent criminal offences, such as smashing Mr Bailey into the wall, or assaults such as throwing two helpless drunk men at the Arundel Park to the ground, or with hitting Tyson Woods at his car when he was standing there talking to Mr Rolf. All this conduct is so obviously unacceptable that it remains to this day astonishing that Mr Rolf continued in his role. And so we adopt the submissions of counsel assisting that the processes of review are so seriously deficient that urgent reform is needed in this respect. All of that is, of course, extremely significant in itself, but it matters all the more because these ugly character traits which we've identified were not left behind on the Tanami Road as Mr Rolf turned off into Yuendamu on the 9th of November. They affected and infected his conduct prior to that day and on that day. We say respectfully, it serves no worthwhile interest to deny or deflect this. Just as all the conduct on the day forms part of the circumstances, so too do the attitudes informing such conduct. Such an historically informed analysis is not necessarily valuable or appropriate in every inquest, but it is in this inquest. Our task here is to urge that the truth be found. And a key reason is so that we, our clients, do not see a repeat of this behaviour of another young Aboriginal person being shot by someone with a demonstrated, known history of racist violence, unchecked and continuing to serve. On the question of systemic racism, the Northern Territory Police Force addresses at length this question of systemic racism in its submissions, concluding that the evidence neither establishes its presence nor establishes a sufficient link to events in 9 November. Where the evidence of racism ranges from evidence of multiple officers, police officers at the Alice Springs Police Station as to its prevalence, extends to TRG awards over years, is demonstrated by the violence, not just of Rolf, but of numerous others in the videos, and which repeatedly did not lead to any meaningful sanction. Considered too with the text of Rolf and others, the text of numerous other witnesses, it is frankly perplexing to read that the Northern Territory Police Force does not accept that there is systemic racism. And again, it cannot and should not be submitted that the presence of systemic racism tars every member. On the contrary, as we've already said, numerous members who gave evidence were impressive and no doubt disgusted by racism. It's not one brush fits all, but important parts of the evidence do reveal systemic racism, and are part of the chain of events that put Mr Rolf in Yuendamu with his well-evidenced and entrenched attitudes and conduct on the 9th of November. We submit that the court should have no hesitation in finding systemic racism in the police force. I can deal briefly with cross-cultural training. It surprises me little how enthusiastic we are on this issue compared to some of the others. But let me explain briefly why. In his 3rd of August Gama speech, Commissioner Murphy said he was committed to, and I quote, enhanced recruit training and ongoing professional education, especially to commissioned police officers with an emphasis on racism, history and the importance of human rights, end quote. So there's something of a dispute between us and the police union and the police force as to how much enhanced education there should be, and we welcome the Commissioner's commitment. However, contrary to those submissions of others, we say that the events of 9 November are clear evidence of the utility of such further training and such education, and that it should be extensive, measured by weeks, not days. It would be a mistake to regard this submission and this argument as merely an academic one, because we say, properly understood, it has dramatic practical effect. The results of such further extensive training would repay the effort in two tangible, enduring ways, which far outweigh the responses put in other submissions. First is if the Northern Territory Police are extensively educated in Aboriginal culture, then they will continue to add to that learning in valuable ways wherever they go in the Northern Territory. And they will have a proper foundation to do so from their training. It won't be ad hoc, it will be systematic and across the force. And from this, their policing will be much enhanced. If the IRT had been trained in this way, as we have been suggesting through the inquest, events on the 9th of November would have included moving slowly and patiently, giving full weight to the importance of a funeral and sorry business, giving full weight to the cultural need to talk, to be patient, to involve family, and of course to involve ACPOs. There would have been no need for confrontational arrest or shooting if they had been properly educated in the areas that I've just identified. In other words, by a better and deeper understanding of Aboriginal culture, the practical task of arresting Kumanjayi would have been carried out very differently, and we wouldn't be here today. With deeper knowledge will come better policing. And the second reason that we say it's a good idea is not one that we're qualified to comment on, but in our view, such training would be invaluable as a marketing tool because it would draw high-quality recruits who would already attracted to the unique policing experience that the Northern Territory offers, would be further attracted by the idea of belonging to the force elite also in its understanding of the rich culture over which it works as a police force. In his Gama speech on the 3rd of August, Commissioner Murphy said that the community should never fear their police and the police should never fear their community. And I quote, "So from today," says Commissioner, "we must, and it will change under my leadership as the Commissioner of Northern Territory Police. I stand here today to publicly commit to lead that change, to transform relations between police and Aboriginal people. It will not be a reset. It will not maintain the status quo. Instead, I intend to develop a new relationship built on mutual respect, trust and human rights." So we urge this court to accept those words of the Commissioner and apply them to the findings and recommendations that we see concerning the carrying of guns, the use of dogs against people of Yuendamu, and allowing community leaders to meet and discuss new police candidates to be stationed at Yuendamu, as we've set out in our submission. On all these questions, in accordance with what the Commissioner said on the 3rd of August, he and his command need to have confidence and trust in the elders. Last week, as one of Yuendamu's most senior elders said to me on these issues that I've just outlined, "Why don't they just try it? Then they will see how well it works, and then it can be done elsewhere too." These are the changes that the community wants, and as the Commissioner said, he will not maintain the status quo. These changes do change the status quo. The court has heard a lot of evidence about Kumanjayi Walker. He was likely born with FASD, his hearing difficulties, his disrupted education and difficulties engaging at school. He's living in overcrowded and deficient housing, and ultimately his regular engagement with the criminal justice system. Two essential outcomes from the inquest are first, through public evidence, to make as clear as possible what actually happened and how it came about. And secondly, for the court to make findings and recommendations. But as our clients have been saying to us, what is going to change? After all, much of what has been learned by the public through this process, and to some extent admitted by various police officers, is well known to our clients. Racism, brutality, lies are not strangers to our clients. Kumanjayi spent much time in custody as a teenager, including in the notorious Dondale Youth Detention Centre. And given what we know of that place, I can assume he was exposed to some horrors there. And as he got older, he remained caught up in the justice system, regularly being detained. So what lessons have we learned from that about rigid systems of punishment where the process obscures the purpose? And so with sadness and with anger, our clients ask us lawyers, we who have the privilege of appearing for the Purrumboo Committee and for the elders of Yuendamu, they ask us, what has Kumanjayi's trajectory taught us? Who is learning from these failings? How is it when the life of a troubled young man is so fully analysed as in this inquest, so publicly examined, how do we suddenly, once again, have the age of imprisonment reduced back down to 10-year-olds? That's what we are being asked. How could society once again be reduced to saying 10-year-old children can be jailed? It will, of course, be Aboriginal children, including perhaps children from Yuendamu. How can these 10-year-olds be jailed and have spit hoods put over their heads? And bearing in mind all of the evidence that we've heard in this inquest, they rightly ask, how would jail and spit hoods have helped a young Kumanjayi Walker? It beggars belief. One might simply ask, how much youth crime would end? How much public money would be saved if the government provided well-funded, well-resourced youth centres open 24 hours a day, providing support, safety, counselling and, very importantly, food, a place to rest and be safe. A significant part of our questions in the inquest and our submissions concerns community leadership. And as we've pointed out in our submissions and repeatedly through the inquest, to understand the myriad of factors that contributed directly to Mr. Kumanjayi Walker's death, it's necessary to understand the systematic disempowerment of the Yuendamu community since the late 1990s, in particular since the intervention in 2007. We've dealt with in our submissions, and so have others, how the failure of the intervention has affected the communities, how the stripping of local power and authority has affected the community, and the consequences of it, the creation of super councils with the consequences that have followed. And in the inquest, we've regularly put questions to the effect of supporting an elected leadership group in Yuendamu to numerous senior officers and members of the Yuendamu community as a means of providing community control over the delivery of services. We say it's a practical recommendation that would materially improve living standards in Yuendamu. And of course, it's relevant to the inquest because such a group, such a leadership body would have very likely altered the outcome of some of the events, if not all of them, on the 9th of November. The debacle concerning the health centre, which others have gone into in much detail, if there was a leadership group properly consulted, speaking on behalf of the whole community, would we have seen a different outcome? One is very tempted to confidently say yes. If there was such a leadership community group in dealing with bringing in a young offender like Kumanjayi after a funeral, would there have been a different process and a different outcome? And in our submissions at 265, we mentioned a recent development, which is the creation of the Kurtji Wita Cultural Authority. And it's appropriate that I just briefly inform Your Honour of that. It's not in evidence, but it's not controversial, and it's a matter of statutory recording. Kumanjayi is a recently incorporated corporation. It's registered with ORIC, the Office of Registrar of Indigenous Corporations. It has a number of purposes which pretty much mirror what's been put to Your Honour through the inquest, which is why it's necessary to bring it to Your Honour's attention. And it includes a leadership group which is made up of each of the skin groups in Yuendamu and leaders from each part of Yuendamu. And in paragraph 264, we set out some of the objectives, which include to form an organisation which represents and reflects Warlpiri cultural values, to arrest social disintegration by promoting programs and policies in accordance with Warlpiri culture, to develop strategies and practices for service delivery appropriate to the needs and requirements of the communities. Now, that would have been absolutely on point on the 9th of November, such as housing, essential services, food, safety, law and justice, and to work collaboratively with both territory and Commonwealth governments. Now, we're bringing that to your attention because it's a new corporation. And at the moment, in our submissions, we've made recommendations or sought recommendations or findings concerning the engagement by agencies and the police with the community of Yuendamu. And at all times we've been putting to Your Honour that should be through the Paramount community. That's still the case because the Kumanjayi Cultural Authority is brand new. And so it's still a question of dealing with the Paramount committee. But the expectation would be over time, and unfortunately, as I stand here today in front of Your Honour, and Your Honour has to write down findings at a point in time, we're in a period of transition. The expectation is over a period of time that would be the relevant body, but Paramount committee still is the relevant body. The new body does not describe itself as being ready to get up and do all of these things immediately. Your Honour just needs to have some appreciation of that complexity. The inquest has already shone a bright light into some very hidden places. And it's certainly the hope of our clients that this court will make findings and recommendations which will be listened to and which will lead to the prevention of any such recurrence. The truth is that after he was shot and handcuffed and dragged across the dirt, Kumanjayi Walker cried out to his captors. He was dying, he was barely educated, he was in agony. But even so, he saw and he said what was truly happening. He accused the police who had done these things and who were with him as follows. You mob got no respect. Shame on you. In 8 words, despite all of these disadvantages in life, he summed up pretty much everything we're doing here and analysing. Your Honour, our client acknowledges with gratitude the efforts made by the court and staff to engage with them as a community through the Lords and other means to make the inquest accessible here or wherever they might be. Your Honour, please.
Thank you, Mr. McMahon. Mr. Bolton, is he the first person to speak for Naja?
Yes.
Thank you. Thank you, Mr. Bolton.
Thank you, Your Honour. Firstly, thank Your Honour for leave to appear from Gadigal country, a court in Sydney. I apologise for not being there. I also wish to pay respects to Kumanjayi's family and to his community and to all the Aboriginal elders who are present at the inquest today. I'm going to talk briefly Mr. Espy will deal more particularly with racism in policing in the Northern Territory. Ms. Mishra will focus on excessive use of force. Mr. Derrig will turn to police accountability and some important submissions about health issues. And then Mr. Murphy, Dr. Murphy, will sum all of that up. So,
Thank you.
Your Honour, Kumanjayi was a young man who was killed by a racist, violent police officer who, although now publicly disgraced by the evidence in this inquest, was generally regarded by his colleagues and even those above him in the line of command as the ideal young constable who could be relied upon to get his man. He shared with his workmates private moments of contempt for Aboriginal people and effete bush cops in unabashed racist, misogynistic and sometimes homophobic text messages. They all thought their privately expressed views were safe, but now they've been exposed, and nearly all of them have claimed they're not really true reflections of their true attitudes, except perhaps in many respects Mr. Rolfe, who now has revealed others. Naja's involvement in this inquest was sought and granted to allow an Aboriginal-controlled organisation to probe systemic and institutional issues relating to Kumanjayi's death. Counsel assisting, the lawyers for the families and the community have joined with Naja in that process, along with the other institutional parties. And Your Honour's identification of the key issues has allowed it to occur, and we are very, very grateful for the thoughtful scope that Your Honour has provided the parties in this inquest. For the most part, we agree respectfully with the findings outlined in Counsel Assisting's thorough submissions and her oral submissions today, but there are some differences, and I regret that because of the nature of this response, some of what we're talking about is a direct response to our differences. The major difference is that Naja has focused much more on the concept of structural and institutional aspects of racism within NT Health and NT Police, and how institutional racism in the NT Police brings about excessive force, and did so on this fateful occasion. To the extent that there's a divergence, our submissions outline our view on the evidence, but essentially Naja submits that the evidence shows that there was racist conduct within the police across a number of stations in the Northern Territory, especially in Alice Springs at the relevant time, and it has continued. What's more, it's our submission that this is not a mere failure of leadership within the NT Police. Racism has been deeply rooted within the institution of the Northern Territory Police. Whilst considering health-related issues, we accept that the best evidence is that the non-Warlpiri clinic staff at Yuendamu did not explicitly seek to be withdrawn from Yuendamu. It's still important to come to grips with the full picture of how those staff conducted themselves in relation to the community and the Warlpiri staff. Naja's submissions focus in particular on community-led and community-preferred solutions rather than mass incarceration. Several submissions today have focused on the 1991 Royal Commission. I was going to say a fair bit about that. I won't duplicate what's been said, but we echo what's been said, that in large measure the recommendations of the Black Deaths in Custody Royal Commission may well, if implemented, have led to a completely different future, not just for Kumanjayi, but for Aboriginal people in Central Australia, the Northern Territory and throughout Australia. The ongoing impacts of colonisation, the failures of the Northern Territory government to reckon with them, have also contributed to what we have submitted is an over-criminalisation of Aboriginal people in the Northern Territory. As Your Honour said on Monday in your judgment in the other very important inquest, the Northern Territory's got the highest imprisonment rate in Australia, very high. It's more significant as an issue in the Northern Territory than anywhere else in Australia, and the Northern Territory has one of the highest per capita prison populations in the world. What's more, the over-incarceration of people in the Northern Territory has meant that many more people have died in custody than ought to have. Since 1991, there's been at least 38 people, Aboriginal people, who died in custody, in police custody. And there's been 43 Aboriginal people that have died in Northern Territory prisons. And then even since Kumanjayi died, there's been about 75 other Aboriginal people that have died in custody nationally. This is a national crisis, but it is not recognised as such by the systems of government. Hyper-incarceration is due to both historical and structural conditions, and much of it relates to social and economic marginalisation, but also to structural and systemic racism. In considering this concept of racism, it is important that there is not simply one type of racism. Individuals can, of course, be racist, and there is very good evidence that Zachary Rolfe was racist. There are very good reason to believe that the vast majority of police and health workers in the Northern Territory are not racists, but they are not consciously racist, they're not individually racist. We commend to you and we reiterate our written submissions that there is a different type of racism which has indirectly contributed causally to the process of over-incarceration in the Northern Territory and impacted on Kumanjayi's life. Institutional racism was described in the Stephen Lawrence inquiry as a collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture or ethnic origin. And it can be detected in processes, attitudes and behaviour which amount to discrimination through unwitting prejudice, through ignorance, thoughtlessness and racist stereotyping that disadvantages minority ethnic people. And it goes beyond individual biases. Our expert report picked up and agreed with that definition. In many respects, it is time for there to be a marking, an official marking of this factor, this insidious factor, in the life of the criminal justice system in the Northern Territory. Marja strongly urges Your Honour to find that there were factors of structural racism in play in the lead up to the terrible outcome of Kumanjayi's interaction with the police on the 9th of November. So I cede the floor now to my colleague, Nick Espy.
Mr. Espy.
Your Honour, Mr. Bolton's given some definition of racism in relation to that report. On face value, Your Honour, there is clear examples of undisputed racism littered throughout the evidence of this inquest. Overt racism, one would think is easy to understand, perhaps a bit easier, Your Honour. But Your Honour has provided, Your Honour, Nadia has provided definitions of racism, including systemic and structural racism. They can be difficult to understand, Your Honour, but it is important to understand those differences and what they mean in light of all the evidence. I'm not going to read them out, Your Honour, but we would urge Your Honour to read them a number of times, continue to read them, Your Honour, and adopt those definitions and then weigh them up in consideration of the evidence, consideration of Nadia's submissions and all parties' submissions. I was deceived by my colleagues. Those were the words of Derek Williams, ACPO Derek Williams, a member of the Northern Territory Police. Officers of high rank have given evidence and stand by their strategic decision to deceive their fellow officer because he was a Warlpiri man, because they could not trust one Warlpiri man post-shooting. This is what their professional experience told them, Your Honour, that there was absolutely no Aboriginal person, even one of their own, that could be trusted. But no one believed that was racist. No one that gave evidence accepted that that was racist. It was just an unfortunate operational decision that had to be made. That's either because they choose to deny it in the face of saving face in public confidence, or they simply don't understand that it was racist, which again, Your Honour, is why I say, in consideration of these definitions, the difficult tasks needs to occur of adopting and considering all the evidence, Your Honour. There is clear evidence of systemic racism, whilst the pages and pages of text messages are definitely overt racism. Systemic and structural racism is evident when a Sergeant Kirkby and Constable Rolfe are conversing about work-related matters in racist ways. It's a systemic issue that's just accepted, and it's not a problem that neither one thought there was an issue with that. Not consulting with ACPO Williams in the arrest planning. The person who knew his community, knew his people, lived there longer than anyone else, and previously arrested successfully the suspect through a slowly and respectfully approach. Further not, as I've said, Your Honour, shutting him out of the decisions post-shooting. He should have been the first person that they spoke to, Your Honour. It should have been, we need to get Derek, we need to talk about who else in the community we talk to about this. Introducing yourselves as police in the community by jumping over the fence and storming into homes, carrying long arms, weapons, pursuing a so-called imminent threat, as if police were behind enemy lines rather than the homes of civilian Territorians, Your Honour. The bush cop mythology that if you kill an Aboriginal person, you've got to barricade yourself, barricade all the white people in the police station, prepare for a siege, rather than reaching out urgently to community elders and leaders and telling them what's happened and helping to control the situation and spread that information. That's not what happened, Your Honour. Instead, the situation got worse. People were left in the dark, literally in the dark outside, not knowing what's going on, continually getting frustrated. But, Your Honour, we would, rather than what Councillor Sisting said, we would suggest that is also evidence of structural and systemic racism, that this was the approach. And there's clear evidence from Samara Fernandez's phone that what was going on outside. Other examples, Your Honour, the whole ruse, the whole commandeering of the ambulance and getting nurses to assist in gathering reinforcements, all the while deceiving the whole community into thinking that the young man is being conveyed by flying doctors to get medical help, and all the while speeding in high speed through the community. Further examples, Your Honour, in the days after the shooting, police continuing to act on this bush cop folklore of, assuming there's danger, walking around in riot gear, carrying long arm weapons, as if it was the community that was the actual threat. Your Honour, all we've seen and heard in these proceedings, if it's not racism, then it's hard to know what racism is. There's an urgent need, Your Honour, to make findings that there is systemic and structural racism. There's also an urgent need to make recommendations about both cultural competency training, extensive cultural competency training, as well as anti-racism training. And I would say, Your Honour, those are two related but separate things. Cultural awareness is not believing that all Opry people are prone to violence. It's understanding things like ceremonial and cultural practices relating to death and funerals are different than Western processes. It's understanding kinship structures and the fact that a kinship uncle might be a useful authority figure that can help to peacefully to help the suspect peacefully comply with police directions. 2 days training is not enough for that, Your Honour. And furthermore, it's not just that on its own, it is a full anti-racism strategy that's needed. An example of Officer Mitch Hanson, who grew up in Good Island, grew up with Aboriginal people, yet still succumbed to issues of racism. Your Honour, I think I'm about to be asked to leave. Your Honour, just very briefly, Your Honour, also we recommend the co-designing of a collaborative community policing model where officers can learn rather than simply hope to be paired up with seasoned cops like Michael Shoemaker or Lindsay Greatorex, who've given evidence. They can't just wing it and hope they're going to learn those skills, Your Honour. And I'll just finally say, Constable Rolfe gave very detailed evidence and demonstrated his knowledge of his training and police procedures. Imagine a situation where, just as he valued those procedures, Your Honour, he valued things like community policing, and that was championed. He valued the notion of working with the community and being anti-racist. Imagine what the outcome would be like, Your Honour.
Thank you. Ms Mishra.
Your Honour, excessive use of force by police officers against Aboriginal people in the Northern Territory has been an issue that has plagued case law inquiries and inquests for many years now. Regrettably, 33 years on from the 1991 Royal Commission into Aboriginal Deaths in Custody, which made recommendations relating to use of force and safe arrest of Aboriginal people, this continues to be a major and unresolved issue. Your Honour, in light of the evidence before you, we ask you to find that there is a prevailing culture of excessive use of force and non-trauma-informed conduct in the Northern Territory Police, and that Mr. Rolfe was a part of this culture. Mr. Rolfe was an officer with a propensity to use excessive force, particularly towards Aboriginal people, and we ask Your Honour to find that this was affected by his racist attitudes. Keeping this background of Mr. Rolfe's tendency to use excessive force against Aboriginal people in mind, we ask Your Honour to find that the ultimate cause of Kumanjayi Walker's death was Mr. Rolfe's use of excessive force in shooting him 3 times, informed by his interpersonal racism or unconscious bias and structural racism. On the basis of these findings, Your Honour, we ask that you recommend the introduction of well-funded community policing, trauma-informed policing, and a safety matrix for effecting safe arrests to the Northern Territory Police Force. Your Honour, turning to the culture of excessive use of force in the Northern Territory Police. The evidence of current and former members of the force bespeaks the prevalence of the use of excessive force and non-trauma informed policing. Also telling is the loose and unregulated manner in which the IRT was formed, trained and operating, with structures that awarded officers who approached their duties with impunity, such as Mr. Rolfe, and permitted them to be deployed in high-risk operations. Your Honour, although the IRT is now disbanded, its formation and operation serve as an important lesson. That lesson being that there is an appetite for a tough cop approach and paramilitary style policing, a warrior style as opposed to a guardian style in the Northern Territory. Policing which causes apprehension in citizens and that is designed to make citizens fearful of consequences, not of arrest, but of death or serious harm. For Aboriginal people, this continues a post-colonial historical environment of police-led massacres, sitting right in the heart of policing. Your Honour, Mr. Rolfe, who was a member of the IRT, was part of this culture of excessive use of force. As the multiple use of force incidents involving Mr. Rolfe examined over the course of this inquest demonstrate, Mr. Rolfe had a tendency to use excessive force. He wanted to, and I quote, get his man, to use Senior Sergeant Andrew Barham's terms, at all costs during arrests, and to express his dominance over Aboriginal men through the use of force, deriving amusement from these uses of force. It is also clear from the evidence, Your Honour, that Mr. Rolfe experienced exaggerated threat perception when interacting with Aboriginal people in the course of his duties. This was clearly illustrated in his interactions with Malcolm Ryder and Albert Bailey, in which Mr. Rolfe acted completely disproportionately. Your Honour, the abundance of evidence substantiating that Mr. Rolfe is a racist, Mr. Rolfe's established tendency to use excessive force, and his exaggerated threat perception when interacting with Aboriginal people, together allow for Your Honour to make a finding that Mr. Rolfe's use of force against Kumanjayi Walker, which ultimately caused his death, was informed by racism. Kumanjayi Walker's Aboriginality served as an othering experience for Mr. Rolfe. Mr. Rolfe perceived Kumanjayi as different to him, not as worthy as him or his colleagues on that night, and that is why he went out looking for him, flouting Sergeant Frost's arrest plan, and used excessive force in getting closer to him than necessary, backing him up against a wall and shooting him 3 times. But, Your Honour, the evidence that the racism that informed the use of force which led to Kumanjayi Walker's death was not limited to Mr. Rolfe's interpersonal racism or unconscious bias. It was also due to structural racism and loopholes in current Northern Territory Police use of force policies and training. Current Northern Territory Police policies and training do not equip police officers with the necessary knowledge and skills to be able to conduct themselves in a trauma-informed and culturally safe manner, particularly when planning and executing use of force, and when confronted with dangerous situations in which split-second decision-making and almost immediate or automatic reactions are required. Training such as the 2-day AMSANT Culturally Response Trauma-Informed Care Module and FASD training mentioned in the Northern Territory Police submissions, although well-intentioned and necessary, lack the requisite level of detail and are unable to capture the wealth of knowledge and skills involved in trauma-informed and culturally safe policing in dangerous and high-pressure situations. Cultural competence and trauma-informed practice in the context of use of force should not be relegated to formal, once-off, or even annual training. Effective integration of these concepts requires engagement in consistent, dynamic, applied training, where feedback is given and superior officers are alive to the issues and point them out, not necessarily as part of any formal disciplinary process, but as a part of an ethos, a commitment to ideals and a form of policing that isn't currently systemic in the Northern Territory. As the Australian Centre for Police Research Guidelines, which Senior Sergeant Barham described as a motherhood document from which all police jurisdictions derive their policies, effective training must incorporate realistic exercise. Therefore, Your Honour, NAJA supports the recommendation of both the implementation of community policing and trauma-informed policing, including the development of a safety matrix for safe arrests by the Northern Territory Police Force. A system where community-led solutions are prioritised and Aboriginal police officers take the lead and are supported by non-Indigenous members. The evidence of ACPOS and the Community Policing Panel clearly demonstrates that community policing is a safer option for remote Aboriginal communities. We ask that your recommendation place an emphasis on the proper funding of community policing. Aboriginal leaders in remote communities have a range of responsibilities thrust on them by government and are often not adequately supported. People are fulfilling multiple roles, and this leads to burnout. Just as members of local councils are remunerated for their attendance at meetings, Aboriginal leaders and community leaders are asked to provide important insights into something so fundamental as police work should be paid just as much as the police and other department staff are. Your Honour, those are my submissions, and I hand over to my colleague, Mr. Derrick, who will speak on police accountability and health.
Mr. Derrick.
Thank you. By 9 November 2019, Mr. Rolfe had already been found to have lied to the local court, and his use of excessive force caused physical injuries to Mr. Ryder. He had 12 complaints for excessive force, 4 of which led to medical treatment of the arrestees. In a properly functioning accountability system, these uses of force, like that against Mr. Albert Bailey in the Araluen Park incident, the Todd Mall incident, and the Malcolm Ryder incident, as well as the judicial finding of lying to a court, should have led to suspensions pending further investigation in the least, if not fired. All of these were clearly evident and available at the time of the shooting, allowing for a proper basis for suspension. Out of all the incidents of misconduct seen in this inquest, only remedial advices were given. Police Standards Command did take disciplinary action in one instance involving an Aboriginal woman who was photographed topless by an officer who had blood across her chest. This was sent to a group chat as a joke. The PSC correctly demoted him and were going to transfer him to Catherine. The decision was overturned by the Commissioner, and all of a sudden, an openly unrepentant officer was transferred to Darwin, where he wanted to be transferred to, and was able to keep his rank. These failures are systemic, egregious, current, and show that the accountability system is utterly and undeniably broken. The solution, however, comes from the recommendations of the Royal Commission into Aboriginal Deaths in Custody. Those recommendations were specifically designed to make sure that Aboriginal people did not die within custody, but inexplicably, it was not implemented in the Northern Territory. The important features of those recommendations are that a system would be totally independent from police, complaint outcomes would be sent to Parliament. With Aboriginal complainants, one of the persons doing the determination should be Aboriginal, and the investigating staff should include Aboriginal people. There is also the internationally recognised best practice model of the Police Ombudsman of the Northern Ireland, which is an investigating service for all issues relating to complaints, discipline and charging of police. Both the recommendations and the pony, as it's called, conform to the expert opinion of Dr. Hopkins' view of best practice, which is that it's independent, adequate, prompt, transparent, and complainant-centred. Our recommendation is that Aboriginal experts should consider these recommendations and pony and tailor-make what is a meaningful and appropriate system in the context of the Northern Territory. Now, turning to health, an important and understated piece of evidence in this inquest is the medical opinion of Dr. Reid, who had the opinion that Kumanjayi Walker could have survived his injuries had the clinic been operating and had the Royal Flying Doctor Service come to Yuendamu. His oral evidence in the criminal proceedings provides that while Dr. Reid did not know the precise skills of the staff or the precise skills of the precise equipment at Yuendamu, he opines there would have been some interventions that could have been performed and others that could not have. But on balance, Kumanjayi Walker could have been maintained long enough to be evacuated and could have survived. This not only means that Kumanjayi Walker's medical care is therefore within the scope of this inquest, but it means that we have to grapple with the real-life implications that Kumanjayi Walker's life could have been saved. These are extremely important issues to consider outside the questions we might otherwise have for police. When NT Health withdrew their services, they did this on the basis of the concern for the safety of their staff. There was risk to the clinical staff. But was their decision a response to a sober consideration of the circumstances in Yuendamu at the time? Was their decision to withdraw proportionate? Did that decision consider the risks to the community members? Was the planning properly done in order to mitigate risk? Was there a consideration of the increased risk to the Yuendamu community, given that their nurses may not be present during the night? Answer to all these questions is no. Our submission is that institutional racism infected this decision. We say this because there was an overestimation of the actual risk to the clinical staff, predicated on the view that Yuendamu was an inherently violent place. There was no consideration of the medical risks of the patients in Yuendamu or Yuendamu, meaning that the medical needs of the community was not even balanced against the safety of the nurses. The Warlpiri clinical staff were marginalised through not being invited to be part of the discussions that led to withdrawal, and nor was their safety considered. There was some views of the staff, the clinical staff, that a message needed to be sent to the community so they would learn that nurses needed to be safe, suggesting that the community was collectively responsible for the actions of a few. And despite there being no known safety concerns in Yuendamu, none of the nurses agreed to be able to go to Yuendamu to service the Yuendamu on an emergency basis. These failings cannot be explained through the concern of the safety of the clinical staff. This is something beyond that, and we say it's evidence of structural institutional racism. Now, turning to the Royal Flying Doctor Service, they decided not to fly to Yuendamu because of the concerns for their assets and their staff. They have stated it was because the police told them to do that because it was unsafe, but this is contradicted by 3 police officers' evidence, including Senior Sergeant Zeng and Superintendent Nobbs. The Royal Flying Doctor Service's concern was baseless, other than being based on the fact of on the preconception that remote communities are inherently dangerous places. Therefore, their decision was also influenced by institutional racism. The solution to this issue is to allow for community control over clinics. Withdrawals might still occur, and in fact, in the case of Congress, when they had to withdraw from Mutijulu in 2021, they had to do so, and they were upfront in their evidence about that. But their handling of this incident was superior, as they had pre-existing policies recognising that withdrawal should not be a punitive measure. Violence is of an individual behaviour or a small group and not the whole community, and there's need for proper consultation. When they did shut down the Mutijulu clinic, they still provided emergency services, including 36 call-outs from Yuendamu, even though all the other service providers were shut. They withdrew in objectively more serious circumstances. Their decision was made in conjunction with the local health board, which means community members engaged in this decision-making. And they also initially from the start planned to get a security guard in order to reopen as soon as possible. They also did post-incident advocacy with the police and through their men's group with the community to make sure that they would not be in a similar issue again. A benefit of Aboriginal control organisations are that they can access primary healthcare access programs, allowing more funding from the Commonwealth. That meant in the past, such an organisation in Yuendamu had 2 GPs, 2 mental health counsellors who were based in Yuendamu, a hearing health worker and maternity and children's coordinator. Most important of all, Aboriginal controlled organisations in health is something that's trusted by the community. NT Health's own policy, Pathways to Community Control, provides that they believe that greater levels of community involvement brings benefit to the process of health and family service delivery and to the health of those engaged. NT Health already have a policy that should transition them to community-controlled organisations. The only thing is that we say that this policy has been around since 2009 and transition needs to happen immediately. And I will now hand it over to Dr. Murphy to conclude.
Thank you, Dr. Murphy.
I want to focus on two topics to finish, and I hope to finish at the end of my submissions on an optimistic note. The two topics will be, first, what I'll call an inquiry mentality and an invitation to Your Honour to grapple with that in a way that's almost impossible not to because of the number of times it's been mentioned. And the second topic will be community-led solutions. On the first topic, I want to, if I may, read out three recommendations. That police services take all possible steps to eliminate the use of racist or offensive language. When such conduct is found to have occurred, it should be treated as a serious breach of discipline. 2, that all police services review their use of paramilitary forces to ensure that there's no avoidable use of such units in circumstances affecting Aboriginal communities. 3, that police services introduce procedures in consultation with appropriate Aboriginal organisations whereby negotiation will take place at the local level between Aboriginal communities and police concerning police activities affecting such communities and the methods of policing used in those communities. Your Honour could cut and copy those recommendations that I've read verbatim from the 1991 Royal Commission into Aboriginal Deaths in Custody. It is impossible not to feel a sense of dismay at the continuing relevance of them. We've identified more than 27 recommendations of the Royal Commission that in Naja's submission bear directly upon this inquest and this death. We've identified 12 other inquests of this court that contain recommendations and findings directly relevant to this death. And we and the other parties have cited to the Dondale Royal Commission, interstate inquiries and ombudsman reports and the like. It cannot be denied that there is a cycle by which an Aboriginal person dies in custody. There is an investigation. Recommendations are made. Those recommendations are not acted upon, and the cycle continues. Mick Gorder, one of the Dondale Royal Commissioners, called this an inquiry mentality, and he said that we need to confront it and avoid a situation where investigation and recommendations are allowed to be a substitute for action. Now, of course, Your Honour is limited in what you can do, but Naja's submissions, and indeed that of many other parties to this inquest, have been focused on trying to put before Your Honour evidence and suggest recommendations to Your Honour that are geared towards enduring change and that are framed in a way to address root causes such that they cannot be ignored. In Naja's submission, this inquest does present an opportunity to break out of this inquiry mentality and the cycle that comes with it, and it presents that opportunity perhaps unprecedented in the history of this court because of the unique body of evidence that the court's heard from, written and oral evidence from community members, the visit to Yundamu, really detailed evidence about Kumanjayi Walker, the deceased, and also Mr. Rolfe, the person who killed him, and a huge body of varied expert evidence from such varied disciplines as use of force, history, anthropology, Aboriginal peacemakers, police accountability experts, Aboriginal elders, of course, Aboriginal police officers, and Aboriginal healthcare providers. Your Honour also has what in our submission with respect is potentially an unprecedented level of participation and we hope assistance from all of the various parties. And so in our submission, this inquest really does present that opportunity to get to the truth and in particular get to the truth of the root causes of Kumanjayi Walker's death. And these are and cannot be denied to be systemic and structural issues. And yes, in our submission, they include racism. And Nick Espy permitted to say something and will not let me sit down unless I say it. and it's this: that racism seems to be a sensitive and sometimes forbidden word. Nobody else will say it except Your Honour. They need you to say it because they can't. They need the findings and recommendations of this inquest to say it for them, to help them so that they can then address it. And in our submission, that really fits squarely with the recommendations of the Aboriginal Deaths in Custody report, which acknowledge that a death in custody has to be seen in its broader historical context. And as Your Honour knows, the Act which empowers Your Honour was born out of that inquest. It is the foundation of this statute and Your Honour's powers. Some other parties would have Your Honour ignore these issues. They are too remote, they say. They are out of scope. NARJA categorically rejects those submissions. They are ahistorical and they do an injustice and a disservice and a disrespect to the institution of the Coroner's Act and this court with respect. As Your Honour knows, one of the powers on Your Honour is framed as an obligation. The court must make recommendations to avoid similar deaths in the future. And it's on that basis that those assisting Your Honour and the parties, and it's hope NARJA has put before the court evidence of potential solutions to the problems that this court's heard about, and in NARJA's submission, the most promising of those are community-led solutions. It's hardly surprising in NARJA's submission that the Aboriginal community and the ideas that they have present the best chance of success of avoiding a similar death like this in the future. For as long as Aboriginal people have been coming into contact with the criminal legal system, they have been thinking of ways to reduce that contact and to make that contact safer. And Your Honour's heard of some of the success and the programs that have achieved that for a time for Kumanjayi, and Councillor Sisting's already referred to the most important of those, Mount Theo and SevGen, 7 generations. But Your Honour's also heard and of course knows from Your Honour's long practice of the obstacles and barriers to the availability of many such programs, the establishment of them and the ongoing funding of them. And some of them weren't able to be accessed by Kumanjayi Walker or re-accessed by him when he needed them most. But there are community-led solutions that Your Honour's heard about that in NARJA's submission are directly to some of the issues that this inquest heard about. The evidence is rich and Your Honour's, it's before Your Honour, I won't repeat it, but some of those solutions are the Groot Archipelago Peacemakers, the Miralinki on Country Drug and Alcohol Program, the larger Manu Kurtaji Law and Justice Group, the various models of community policing that Your Honour's heard about, night patrols, and of course, Congress and Aboriginal-led health service delivery. NARJA commends that evidence to Your Honour and the spirit in which it was put before this court. It submitted that these type of programs offer the most promise of lasting change and ought, with respect, be the focus of Your Honour's submissions, recommendations. NARJA's ultimate submission is that Aboriginal people have the answers to the problems that this inquest has heard about, and NARJA asks the court to listen to those suggestions.
Thank you, Dr. Murphy. Should we take a 5-minute break just to give you a chance to have people survive another hour or so? We'll just take a very short break, about 5 minutes, and then we'll resume.
Silence will stand to the coroner's court in the Northern Territory.
I was worried about you, Michael. Tapping away there,
loud,
I thought, yeah. Maria? No.
Stand. The coroner's court of the Northern Territory is now in session.
Can I thank everyone for being very considerate to each other and very much sticking to the time limits that were allocated for submissions. Mr Officer, I understand that you've asked for approximately an extra 15 minutes and I'm happy to accommodate that, and we will sit through this afternoon so that you can have that additional time.
Thank you, Your Honour. And Your Honour, I hope you don't think less of my sartorial elegance for not wearing a blazer. I haven't been able to get home from Darwin for some time to obtain a suit, so I'm in true territory rig. Your Honour, I intend to deal with my submissions, which is obvious from the way in which they have been put in writing, in two parts. And that is, Your Honour, scope, firstly, and secondly, 9 November 2019, including responsive to what some parties have put to Your Honour today. As we have said, now that we've reached this stage, or Your Honour have reached this stage of this inquest, with respect, of course, we say that it started on an erroneous evidentiary basis, it was beyond scope, and it exceeded jurisdiction. We maintain that position, and I'll elaborate shortly on why it is appropriate that we raise it again at this juncture. Your Honour, it's now time at this stage, we say, to appropriately and properly confine this process and your investigation come the time of exercising your statutory powers and functions. Confine it in its scope, confine it to what is relevant, and confine it so that so as not to undermine the jury verdict or infringe upon the prohibition set out in section 34(3), so that you exercise your statutory powers and functions within the proper limits. Your Honour, for if you accept what others are urging upon you in some, not all issues, with respect we submit, you will fall into error. Where we part ways with others on the controversial issues which are obvious from the submissions and how the inquest has been conducted, what others are urging on you to do, you must not, or it will cut across the sanctity of the jury verdict, and our respectful submission lead you to act in prohibition of section 34(3), that is, making findings or comments that an offence may or has been committed. Your Honour, what parties are urging you to do in respect of those controversial issues, if accepted, will in truth give it the hallmarks of a royal commission into Zachary Rolfe, seeking to try and alter the outcome. And in our respectful submission, Your Honour, you cannot do that. Your Honour, some criticism has been levelled at us from NAJAR that this is a re-agitation or litigation of matters already decided upon. And whilst you don't need to decide the concepts of abuse of process, it's inherent that that is what they are suggesting. Your Honour, there is nothing, I submit, inappropriate about pointing to potential error at this stage, because it's now about use of evidence. You've decided to receive it. It's now what use you can make of it and for what purpose. And purpose, which I will outline in these submissions, looms large, Your Honour. As the cases say, to take judicial review or some other challenge to evidentiary rulings at the commencement or during an investigation is premature. That's Thales at paragraph 67 and WRB Transport v Chevelle, where similar challenges to the receipt of evidence were taken and the higher jurisdiction suggested that that was premature. So, Your Honour, there is nothing inappropriate about going back to the receipt of evidence and what you can do with it now. And on that basis, I advance the following two propositions with some overlap. Your Honour, I will deal with what I characterise as the errors from the outset, by reference to rulings 2 and 3, and then the errors you risk running into. And the way I characterise that, Your Honour, is by following the bouncing ball to determine liability. And what I meant by purpose earlier, Your Honour, is what is the purpose for which you've received the evidence? What is the purpose you can make use of that evidence? And what is the purpose that other parties are urging you to do with that evidence, where we suggest, Your Honour, may lead you to error? As Your Honour is well versed in the authorities, having them been canvassed in this inquest to date on these arguments, what permeates the vast majority of those is that, yes, they are broad that is, coronial inquiries are broad, but has as its boundaries common sense. Common sense when you're determining a factual inquiry as to what led to the cause of death, common sense as to what circumstances can reasonably be inquired into to determine a cause of death. And Your Honour, to that end, I commend to you paragraph 28 of our paragraph, which is reference to our WRB Transport and Chevelle. And what Justice Lander was doing there was espousing that cause and circumstance are two different things. Cause being the legal cause, that is a question of fact, which, like causation in the common law, must be determined by applying common sense. Coroner, therefore, has to carry out an inquiry into the facts surrounding the death of the deceased to determine what, as a matter of common sense, has been the cause. And near the end of that paragraph, that is a factual inquiry which only has as its bounds common sense. He then goes on to deal with circumstances, Your Honour, which he adds as an additional jurisdiction to Your Honour, and we agree with that. And the jurisdiction is to determine the cause of the death of the deceased. There may be some circumstances surrounding the death of the deceased which, although not operating directly as a cause of the death of the deceased, are relevant for the coroner's inquiry. The circumstances surrounding the death of the deceased may be important for the purpose of the coroner adding to his or her findings recommendations which might prevent or reduce the likelihood of a death. And, Your Honour, as we indicate in our submissions at 29, what we submit Justice Lander was really getting at there was, albeit cause of death and circumstances relevant to a death are separate in their concepts, the circumstances of a death must be tethered to making recommendations to avoid reoccurrence of the death. It's not some continually broad-ranging inquiry. And indeed, the language between sections 34 and sections 26 of your Act, the Coroner's Act, that is, tend to suggest that our submission is on all fours with that, because section 26(2) says coroner must make such recommendations with respect to the prevention of future deaths in similar circumstances as the coroner considers to be relevant. And section 34, Your Honour, the coroner investigating a death must find any relevant circumstances concerning the death. So in my respectful submission, Your Honour, the fact that you must find circumstances concerning the death does not give a broad range of inquiry. Can I turn to your Act, Your Honour, the Coroner's Act, and what gives you jurisdiction to investigate a death finds itself in section 14. Your Honour then has jurisdiction to hold an inquest under section 15. And Your Honour, stating the obvious, but it's what the authorities say, without a death, you have no jurisdiction. Section 26, 1B, is a power. That is a power to report on a matter in relation to the administration of justice. Crucially, Your Honour, that is relevant to the death. Section 26(2) imposes on you a duty. That is, a duty to make recommendations to prevent death in similar circumstances. And so there's a delineation, Your Honour, between must and may. That is duty as opposed to power. Under section 34, the coroner must, and here we find another duty, find the cause of death. Your Honour also has a duty to find any, once again crucial words, relevant circumstance concerning the death. And as Justice Nyland said in Perry and Shivel at paragraph 54, it's a coroner's statutory duty to find facts. Section 34(2), Your Honour, is a power. That is a power to comment on a matter in relation to the administration of justice connected with the death. Section 34(3) is a duty. That is, you must not include in any finding or comment a statement that a person is or may be guilty of an offence. Section 35(2), Your Honour, is a power. That is a power to make recommendations in relation to the administration of justice, once again, connected with death. And Your Honour, I just want to pause to explain why I emphasise the fact that connected with a death has significance to this argument. In Thales, Your Honour, at paragraph 71 through to 73, there was an argument put in that case that because the coroner had made a finding, that is a factual finding, that they were unable to determine the death or unable to make a finding in that case of electrocution, that therefore meant the coroner could not go on to exercise the powers, that is, to make comment or recommendations. But that was rejected, and it was rejected for this basis. There may be cases where the cause of death is uncertain, but that the circumstances in which the death occurred give rise to significant and substantial matters relating to public health and safety or the administration of justice. Neither the text of Section 67 of the Coroners Act, so Your Honour, that Section 67 is very similar to Section 34, when read as a whole, limit the power of the coroner to comment on such matters, provided they are connected with the death which is being investigated. In that case, Your Honour, the words connected with the death, relevant to the death or relating to the death, did not feature in that particular provision, and so the Supreme Court rejected an argument that you couldn't then go on to make findings. They then went on to say it's hypothetical to consider whether the calling of a particular witness or particular evidence might infringe on the prohibition on not inquiring for the sole or dominant reason of making comment or recommendation. And, Your Honour, that authority comes from Harmsworth. And Your Honour would be familiar with Harmsworth, where in that case Justice Nathan said this, starting at page 995. Coroner's source of power of investigation rise from the particular death or fire. Coroner does not have general powers of inquiry or detection. The inquiry must be relevant in the legal sense to the death or fire that brings into focus the concept of remoteness. Then goes on to explain, of course, if there wasn't a fire in the prison, there wouldn't have been a death, etc., etc. Such an inquest would never end, but worse, it could never arrive at a coherent, let alone concise, findings required by the Act, which are the causes of death. Such an inquest could certainly provide material for much comment. Such discursive investigations are not envisaged, nor empowered by the Act. They are not within jurisdictional power. Inquiries must be directed to specific ends, that is, the making of findings, as required and set out in Section 19, that is, Your Honour, findings of fact. The power to comment arises as a consequence of the obligation to make findings. It is not free-ranging. It must be a comment on matter, any matter connected with the death. Powers to comment and also to make recommendations are inextricably connected with, but not independent of, the power to inquire into a death for the purposes of making findings. They are not separate or distinct sources of power, enabling a coroner to inquire for the sole or dominant reason of making comment or recommendations. It arises as a consequence of the exercise of a coroner's prime function, that is, to make findings. The extensive powers of investigation and inquiry, which I have already noted, attach to the purpose of making the findings, which the coroner must, if possible, do. And then later on, Your Honour, the words to investigate was explained as a verb, which is used in its ordinary plain English way, but that does not expand or illuminate the concept of relevance or causation. But the power to comment is incidental and subordinate to the mandatory power relating to how deaths occurred, their causes, and the identity of any contributory persons. Your Honour, you can't just ignore the Act, in my respectful submission. Even if it was born out of the Royal Commission, as Najjar just said, arguing its parameters has nothing to do with showing disrespect to the Act. This is set in a particularly structured way for the reasons I have outlined. And I want to take you to your rulings, number 2 and number 3, as to why we make good the submission that there was an error from the start, that it's appropriate to raise it at this stage. In ruling number 2 at paragraph 18, dealing with the evidence on Mr. Rolfe's phone, you said this: in my view, the evidence should be received. And there was an argument you might recall about the lawful interrogation. In addition, and you received it under section 39, I consider the evidence is appropriately directed to and capable of bearing upon the issue of what, if any, finding or recommendation I should or must make under sections 26(1), 2 and 34 of the Coroners Act. Your Honour then went on at paragraph 33. I would have exercised the discretion to receive the evidence, again, this is the mobile phone evidence, in light of the subject matter and potential significance to the question of what, if any, findings, comments and recommendations I should or must make under sections 26, 34 and 35 of the Act. In dealing with remoteness, Your Honour said for present purposes it is unnecessary and appropriate for me to characterise the text messages. The question is whether it is appropriate to receive them under section 39 for the purpose of investigating the death, and ultimately for the purpose of determining whether, and if so, in what terms, I may or must make a finding or recommendation under section 26, and so on you go, and say you would not have investigated the matter if there was no evidentiary basis about Rolf communicating racist views. You then say at paragraph 37, I am satisfied that this could amount to a relevant circumstance connected with the death or a matter connected with public health or safety or the administration of justice that is relevant to the death or bear upon the prevention of the future deaths in similar circumstances. Your Honour, in ruling number 3, and I won't go through all of them given the time limits, but it's where you dealt with in much more detail the objections to receipt of particular types of evidence. And at paragraph 49, you rely on essentially the same reasons you gave in ruling number 2 for rejection. And once again, Your Honour, you go down the path of admitting the evidence by virtue of section 39, but linking that because it may be relevant to the matters of section 26, 34 and 35. Your Honour, what I submit in that respect and with respect is that there was a conflation between your statutory duty to make factual findings and then your discretionary power to make comment or recommendations that follow from that. And Your Honour, that is what we say belies the error in when the evidence was received at first blush. Your Honour, there's a reason why that is also important and why, again, we can raise this or bring this to Your Honour's attention now. And that is because of what Justice Lander said in Chevelle, WIB Transport and Chevelle. In due course, bearing in mind he said the objections and the argument for judicial review was premature, some of the evidence may become irrelevant. Other evidence, yet undiscovered, may become relevant. The coroner will determine that at the time of reception of the evidence. Some evidence which has been received in due course may be ignored. Some may become clearly wrong. Other evidence will be unreliable and some irrelevant, but that will be a matter for the coroner at the time he makes his findings. And Your Honour, because of what we respectfully submit, the conflation in which you receive the evidence, because your statutory function is to make findings of fact, the receipt of the evidence at first instance was in error because we respectfully submit you considered what you may do with it in terms of comment and recommendations when it has to be received, Your Honour, at first instance to make findings of fact as to cause of death. Not whether something might be reliable or can be relied upon later to pass comment or to make a recommendation. It must first be absolutely tethered to it being relevant to cause of death. And Your Honour, can I say this about relevance, which came up in the Territory Coroner, Rolf v. the Territory Coroner, 2023 NTCA, at paragraph 47. In the performance of that function, coroners exercise wide investigative powers and, where necessary, conduct inquests to receive evidence before recording findings and comments. In the conduct of inquests, the inquisitorial aspect is maintained by the fact that coroners are generally not bound to observe the rules of procedure and evidence which apply in courts of record. However, it is now well recognised that coroners must act judicially in the use made of evidence of low probative value or of a probative value that cannot be properly evaluated without applying the relevant rules of evidence. And the court went on to say at paragraph 52, the requirement to act judicially is not only to carry out a decision-making function rationally and reasonably, rather than arbitrarily. And Your Honour, the issue of relevance came up in the Commissioner of Police and Clements, which I think was cited by Najar to say, well, you just have this broad-ranging discretion to determine what you think is relevant yourself. But Your Honour, that misses the point. The touchstone is relevance. That's what that decision says. If it's not relevant to a cause of death, Your Honour, in my respectful submission, it was an error to make it relevant by thinking it might help or assist in comments or recommendations that you might later seek to do. Your Honour, and in fact, in Saraf and Johns, recommendations and comments can be invalid, and if they are, they're in excess of jurisdiction. Your Honour, there's one other point which I respectfully submit makes good the argument. Firstly, why, as Supreme Court authority has held, that You can't just admit evidence for the purposes of comment and recommendation. And why this argument is not an abuse to raise it now. Unlike other acts, and there's a case out of Queensland which was the Hurley v Clements. In this case, in your Act, Section 44, and I don't mean this in any pejorative sense at all, Your Honour, says that the Supreme Court may declare some or all findings of an inquest are void, and the Supreme Court may make an order under that section if it is satisfied that it is necessary because of consideration of evidence. It's such a broad ability, Your Honour, for there to be an error in the consideration of evidence and necessary for the Supreme Court to set aside any finding. Unlike the case in Hurley and Clements, what they were dealing with there is there had to be a finding against the evidence or against the weight of the evidence. My respectful submission, Your Honour, this is much broader in that if you erroneously considered evidence and if you erroneously accepted it for the purposes of only making comment or recommendations at a later stage and not being relevant or tethered to the cause of death, then there is serious concern, Your Honour, as to whether or not you can make use of that evidence at all come your fact-finding process, which you are now about to embark upon. So that is, how can it be permissibly used, and if it can be permissibly used. And Your Honour, when you follow the bouncing ball, which I mentioned off the top, you can't use that evidence. In my respectful submission, not only was it received in error, its use would be in error, not only because it's irrelevant, but also because it infringes upon the prohibition in the Section 34(3). And again, Your Honour, I remind you all of the approach the courts take as to the common sense boundaries that apply in your fact-finding mission. So, Your Honour, I want to turn to the submissions we make about potential error Your Honour might fall into should you consider the evidence and the submissions that parties are urging upon you, which we respectfully submit not only cuts across the jury verdict of acquittal for Mr Rolfe, but also Section 34(3), that is the prohibition on making any comment consistent with an offence being committed. Your Honour, there's a myriad of them, but I want to deal with select few, the parties' submissions to date. This is where we say, as attractive as it might be, Your Honour, you run the risk of falling foul of those two issues that we raised, the verdict and the Section 34(3) prohibition. Your counsel assisting at paragraph 562C says, as a result of this lie, and this is the lie dealing with the Kumanjayi Walker grabbing of the Glock, which I'll deal with later, the lies Mr Rolfe told regarding the broader events of 9 November 2019 and the significant issues with his credibility as a historian of his own use of force, the coroner could not accept even on balance Mr Rolfe's evidence that he feared for his own or Constable Ebell's life when he fatally shot Kumanjayi Walker. And as Your Honour heard today from your counsel assisting, there was an extrapolation of that you might find he has this tendency to use excessive force, tendency to act on violent or racial attitudes or predispositions. NAJA, Your Honour, in their primary written submissions, paragraphs 42, take it to the next extreme. If the good faith defence had been abolished, maybe the shooter would have been held to account for his actions and become the first police officer convicted of the death of an Aboriginal person in custody. NAJA, in their reply submissions at paragraphs 47 to 52, in rebuttal to what we put about Justice Byrne's decision on tendency, say, well, he was only dealing with 4 instances. You've received evidence, and I remind you of our position on whether or not that's in error, Your Honour, of all of these tendencies. And they lead to the ultimate conclusion that come the 9th of November 2019, all 3 shots were fired in excessive force. That is adopted by the Brown family at page 14 of their annexure to their reply submissions. NAJA today in their submissions suggested that the Kumanjayi Walker's death was by use of excessive force and had, my words because I missed them, but along the lines of racial predisposition. And Your Honour, the Walker Lane Robertson family, in their submissions, say finally it also bears examination that no one has been prosecuted for the first shot following the unlawful entry and arrest attempt, nor have Abel's criminal liabilities both as principal and as investigated, given he led Rolfe into the house, used physical force, and on it goes. Your Honour, I remind you of what we said, paragraph 91 of our submissions, why you must exercise absolute caution in being attracted to the bouncing ball position parties are taking, and that is this. Notwithstanding these contentions, which are attempts to undermine the jury acquittal, the coroner is expressly prohibited from making a fine of excessive force at all, and in relation to the incident of 9 November 2019, not only prohibited from making a finding of excessive force, but also cannot make findings about Rolfe's state of mind and or apply a legal standard to aspects of Rolfe's conduct and or suggest that the conduct of Rolfe was unlawful. This is so because the conduct and reasonableness of that conduct in relation to the three available defences relied upon by Rolfe formed part of the issues joined at trial. To make these findings is to go behind the sanctity of the jury verdict. Your Honour, can I perhaps do it this way by analogy? And we've referenced the case of Balog in our submissions, which was an ICAC investigation where they ran a similar application that there shouldn't be any findings consistent with the statement that someone's committed an offence, which ultimately the Supreme Court held. But that's different because ICAC, in that particular case, and as it stands as a statutory body, its very purpose is to investigate and expose corruption. And if there is corruption, it's to make recommendations to the DPP that they think corruption is being committed. In other words, if a developer comes along and hands $10,000 to the minister and says, give me development approval, that is corruption. And that's their task, to find that and to weed it out. But if, for example, in the coronial context, let's say a body is found, the person has clearly been murdered, let's just say for argument's sake they're naked, face down, stab wounds, it's then the coroner's task, your statutory duty, to determine the cause of death and your statutory duty to determine the circumstances. So first you deal with causation, was it a stab wound? You then turn to circumstances, and that could include this. Where that person was last seen. Whom were they with? What did their phone? What does their bank statement say? Who did they meet? Where did they go? And how did they end up at the place where they are now? You might get to a conclusion, Your Honour, that the identity of the last person to see them was X. That's not this case. We know Zach Rolfe shot Kumanjayi Walker 3 times. We know the second shot resulted in his death. We know that the lawful killing principles were joined at trial: self-defence, good faith defence, reasonable performance of duties. I go back to what I reminded Your Honour I would emphasise: purpose. What possible purpose is there in making findings of fact on use of force, prior, text messages, state of mind, and whether there's a tendency for any sort of proclivity, then applying a legal standard to those things, other than to suggest that these other parties are urging upon you, including your counsel assisting, that an offence had been committed? What possible other purpose? Bearing in mind the constraints, it would be in complete contravention of section 34(3). Your Honour, we go so far as to say that it would undermine the jury verdict of acquittal. We don't quarrel with the fact that Your Honour can still investigate the same circumstances which was subject to a criminal trial. But you come back to purpose of what the parties are urging you to do, what use you can make of the material and the evidence you've received over objection. And Your Honour, I want to follow on with this idea of not being attracted to simply just following the bouncing ball. In fact, the analogy I gave you about the murder, the clear murder of someone, but who knows who did it. And this is what Justice Blue said, the decision of Bell. In that case, the relevant provision prohibits the court making a finding or suggestion of liability. It does not prohibit the court making findings of fact that comprise one or more elements that may give rise to liability without a conclusion that liability arises or may arise. However, if the court made a series of findings of fact which encompassed each and every element that give rise to liability, that would probably be tantamount to a finding of liability, even if the court did not explicitly draw the final conclusion that liability exists. So, Your Honour, in the first example I gave you, that is, that determining the cause of death, you're making findings of fact, who might have information about or who may have caused the death. But in the example, as in this case, what the parties are urging you to do is effectively construct, as Justice Blue put it, the elements of findings as to an offence, which would be in contravention of section 34.3. That's following the bouncing ball, Your Honour, which leads to the only and solely conclusion that what Zach Rolfe did on the 9th of November was murder. That's how the parties have put it. Your Honour, I go on in respect of our submissions at paragraph 115, Kuhn and Khan. It follows that a person who killed necessarily contributes to the cause of death, and that is nonetheless true where the killing is in lawful self-defence. A coroner is not concerned with the latter question, but will ordinarily set out the relevant facts in the course of finding how the death occurred and the cause of death. The facts will speak for themselves, leaving readers of the record of investigation to make up their own minds about lawful self-defence on any or any similar issue. Paragraph 116, we cite Justice Nyland and Perry and Chevelle. Finding of criminal or civil liability requires the application of the relevant law to the facts in order to determine whether the essential elements of a given crime or civil obligation have been made out. Your Honour, I'll deal with excessive force, which is really the key topic that looms large in the tendency argument that parties are trying to run. And Your Honour, Najar drew attention to this, the case Angara and Rigby 2021. Justice Kelly said this, bearing in mind this is an appeal from someone who was convicted for resisting arrest, so it doesn't necessarily bear similarity to what we're dealing with here, but Justice Kelly said this at paragraph 34B. A police officer acts in the execution of the officer's duty from time the officer embarks upon a lawful task connected with the functions of a police officer and continues to act in the execution of that duty for as long as he is engaged in that task. C, it is not part of a police officer's duty to engage in unlawful conduct. The use of force by a police officer is subject to limits and, beyond those limits, is unlawful. Police officers use greater force than the officer cannot be said to be acting in the execution of his duties. And so, Your Honour, what the parties are effectively saying to you is that make all these findings of fact about excessive force, apply a legal standard, that is, it wasn't reasonable. Inquire into Rolfe's state of mind. What was he thinking? We suggest he was lying or making it up. Your Honour can't do that. Kuhn and McCann says as much. You can make findings of fact about what Zach Rolfe did, what he saw, what he heard, but you can't then take the next step of applying a standard, a legal standard, to then say it was excessive force or it was unjustified or it was unlawful. And that's what everyone in this room, with the exception of a few, are asking you to do. With the greatest of respect, Your Honour, it will lead you to error. You cannot make any finding that Zach Rolfe at any point in time, especially not the 9th of November, for it cuts across the jury acquittal, any excessive force. So, Your Honour, there's two ways to then look at it. If you accept, as we say you must, with respect, that you can't make any finding of excessive force, then every single matter that this inquiry has gone down, every topic, is irrelevant. It simply falls away. There's no need to worry about his prior use of force history because you can't make those findings. There's no need to inquire into whether racism played a part, as the Northern Territory Police Force have agreed with us. There is no direct evidence of that, but it has no relevance to cause of death. And Your Honour, would be an error to receive and use that evidence now simply for the discretionary purpose, that is, applying a power to make comment or a recommendation. They are irrelevant in the strictest sense of the application of relevance. Your Honour, relevance is the touchstone. Or put it another way, Your Honour, given you have a statutory requirement to make findings of fact. The fact of Zach Rolfe's prior use of force, so what? You can't make any finding of excessive force, only that he used force. The fact of a racist message, so what? The racist message is not causative of Kumanjayi Walker's death. There were no messages proximate to or directly dealing with Kumanjayi Walker, nor is it a circumstance relevant to cause of death. in one respect, Your Honour, you don't get past first base to then go and consider second base about whether or not it's relevant to a comment or relevant to a recommendation you make. I mean, a racist message has nothing to do with the administration of justice. Your Honour, the fact of a misogynistic message, so what? For all the same reasons I've outlined. Campagnaro's evidence, so what? It has no utility to determining cause of death, which we say was made absolutely plain during the trial and is no great mystery. It has absolutely no utility because you can't use it for the sole purposes of making a comment or a recommendation. And, Your Honour, you certainly can't, following that bouncing ball, reason tendency. The state of mind of Zach Rolfe is joined with the defences he ran at trial. The state of mind of the person who uses force, only he will know. It's not a finding of fact you can make. The reasonableness of that conduct, which is a legal standard, you cannot make those findings of fact. Because, Your Honour, you can't make findings of fact on those matters, and because the matters of which you might make findings of fact, such as it was a racist text message, you can't then go on to use it in the greatest of respect to suggest that that all leads to a tendency that come the 9th of November 2019, it was racially motivated, it was excessive, it was unjustified, it was unreasonable, and the defences that were available to Zach Rolfe are somehow cut across and simply forgotten. Your Honour, that is the error that you seriously run the risk of entering into if you accept a position that parties urge upon you to so accept. Right, can I deal with the text messages as I move to 9 November? We respectfully submit and maintain that the messages going again to use were unlawfully disseminated to the Coronial office and investigating intent. They should not have been received. And, Your Honour, we say that in this respect, the ruling Justice Burns made with respect to the trial was the seizure and subsequent download of the mobile phone. Is there something? The use of the messages, Your Honour, would have been readily apparent when someone looked at those messages, and naturally one might think you start with the 9th of November or the 10th or shortly after, they had no direct connection to the shooting. Those messages should have been put to one side straight away, and continual interrogation should not have been permitted. Certainly should not have been received because they have nothing to do with the cause of death, and Your Honour cannot use them simply for the purposes of recommendation. It was those messages, Your Honour, that laid the foundation for this broader inquiry into racism. And then ultimately, Constable Rolfe gets in the witness box and he's asked, have you heard or seen racism? And he says, yeah. TRG stuff. Well, your counsel assisting says, as do others, well, that's just self-serving. It's not self-serving, Your Honour. He's asked a question, he gave a truthful answer. But the foundation for that inquiry, which we say is beyond the scope, started with a beyond the scope inquiry into his mobile phone. There is no evidence, Your Honour, as the Northern Territory Police Force recognise, that Kumanjayi Walker's death was because of racism. And, Your Honour, it is incredibly unfair and without foundation in the evidence to attach that label to it, as others are, in respect of Mr Rolfe. Now, we're not saying racism can't be a topic. It would be ridiculous. But racism could have been explored in this inquest in a myriad of other ways, such as the involvement of Indigenous police officers, guns in community, lack of or minimal cultural education, training. Should use of force principles apply differently in communities? Simply asking a witness, have you heard or seen? As Mr Bowe submitted to you today, why Yuendamu was a failed policing project. But we don't shy away from the fact that racism might be a relevant topic. I haven't said as much. What we have said is text messages should not have been received. They don't reveal any great direct correlation, and nor can you use them to somehow suggest they had any influence on Mr Rolfe's conduct on the 9th of November. Then we have this extraordinary situation that, having been compelled to give evidence in the witness box about racism, and he revealed the TRG, which everyone thought Mr Rolfe was lying about, and in fact Councillor Sisting put to him, you simply said that because you didn't like Meacham King's answer that this wasn't intelligence gathering. Mr Rolfe produces the certificates. Those TRG officers give statements. They were false. But Mr Rolfe was examined uphill, down dale, about said few text messages he exchanges in private with people, text messages the inquest should never have had, and exposed no assistance to Your Honour in your statutory task come the 9th of November. Quite apart from this inquest looking at the oversight and supervision of Zach Rolfe, in other words, that were used as an exemplar, he became the target in the way in which the messages were deployed, the way in which he was cross-examined, and the way in which parties put to you what Mr Rolfe said in the face of those 5 TRG officers lying in their affidavits was just self-serving. Oh, that should be rejected. Your Honour, I want to turn to 9 November. Submissions that have been made today and some others. Start with this, Your Honour. Zach Rolfe, Peremptory Committee, rightly acknowledged, has no obligation to prove anything. He has no duty to this inquest to prove something or a fact. That is not his task. In fact, at paragraph 28 of the decision of Dugan, it seems to suggest that, in fact, that would be a level of unfairness. What Dugan says is, once evidence of a particular issue were admitted, those who feared that such evidence might form the basis for adverse comments concerning their conduct would inevitably wish to challenge it and to call other evidence to rebut or qualify it, yet the admission of further evidence might raise further issues and hence generate applications for still more evidence to be called. Thus, a coroner might be constantly torn between the need to contain the scope of the inquiry and the need to ensure that all interested parties were treated fairly. More fundamentally, the section does not confer jurisdiction to conduct inquiries of that scope. So, Your Honour, it's not fair to just say, well, there's ample opportunity to call evidence and adduce evidence. Zach Rolfe has objected to a number of categories of evidence. He has no obligation, no duty to produce evidence to this court. Your Honour, your counsellor Sisting submitted today that unlike officers on 9 November, there was no recent event that would have elevated his, that is Kumanjayi Walker's risk profile because no violent behaviour had been exhibited. Well, Your Honour, he attacked cops with an axe only 3 days earlier. But that's, again, the bouncing ball of trying to set up that come the 9th of November, predisposition in the tendency that Zach Rolfe had somehow meant that the 9th of November puts itself in a different category because there was no violence for 3 days. As the system has said, this is not to criticise or demonise. Then, in the same breath, says Mr Rolfe was undisciplined, egotistical, contemptuous, particularly contemptuous of Frost. Labor, your counsellor Sisting said this. When they arrived at the Uindamupa, that is Mr Rolfe, Mr Kirsten spoke with Frost. Compelling evidence was your counsellor Sisting's submission that officers were not interested in what she had to say. Rolfe and Kirstenfeld knew the existence of the 5 a.m. arrest plan. Your Honour, can I remind you what Julie Frost said in cross-examination in this inquest on that particular topic? Question. Thank you. When you told us that, I can't remember the exact words that you used, but you certainly weren't flattering about the way in which Officer Kirstenfeld spoke to you. Your Honour, challenging. Right. Mr Edwardson, in other words, you didn't like the way in which he spoke to you. Answer, no. No. Question, that was him, the way he presented to you and how you felt inappropriately he spoke to you. Answer, yes. Question, that's certainly not what happened in the case of Zachary Rolfe, though, is it? Answer, Constable Rolfe didn't say a thing. Other than hello, he didn't say a thing the entire time. Question, all right. Answer, and I actually believed he was listening to what I was saying. Question, right. So you believed that Zachary Rolfe was being attentive to what you were saying. Answer, yes. Question, and your evidence, as you can now recall, is that he apart from saying hello, he didn't say anything else to you at all. Answer, no. Question, no, that's your best recollection, is it? Answer, yes. Question, so there was certainly nothing about his manner, demeanour, conversation, or anything of that nature that you thought was inappropriate? Answer, no. transcript 929 to 930. But Your Honour, everyone here will have you believe that Zach Rolfe's misogynistic messages meant, he just disregarded Sergeant Frost come the 9th of November. With greatest respect, Your Honour, that ought to be rejected. Authors of the transcript I just read you make it absolutely plain as day. Sergeant Frost felt no disrespect. Constable Rolfe, and any suggestion, the danger of using messages that had nothing to do with the cause of death or the circumstances of it, that somehow some earlier point in time you sent a message which might have misogynistic connotations, means you draw the conclusion and the tendency that it didn't obey Sergeant Frost on the 9th of November. Your Honour, that's the danger of the bouncing ball that parties are urging upon you to accept. Councillor Fisking said, while I'm on that topic, Your Honour, you might also recall, and I think it's brief item 3170, that there was an email from Tanya Mace to a number of officers, including Mr Rolfe, thanking them for the way in which they handled a very difficult operation. Tanya Mace is a female. She also mentioned that they understood what it's really like to be a bush cop, given that particular operation. Your Honour, once again, that hardly has any connection to what parties are suggesting is Mr Rolfe's disrespect for bush cops in private messages means he was simply just going to disregard them. Recommendation from Tanya Mace, female police officer, a bush cop, about their behaviour in a particular operation, speak volumes. Your Honour, no police officer has come to this inquest who has worked with Constable Rolfe, female and male, Vickery, Gould, to name a few, Bowens, Kirkby. Have anyone suggested that Mr Rolfe was otherwise professional, courteous, in his discharge of his duties? And Your Honour, the text messages to somehow suggest that should be undermined, messages in private, messages that should never have been explored, have absolutely no relevance, Your Honour, to how Mr Rolfe conducted himself using the evidence that they underpin the way in which he conducted himself. Your Honour, as to the 5 a.m. arrest plan, sure, Constable Rolfe acknowledged, I don't even think it's tacitly, that he knew, at least broadly, of this concept of 5 a.m. But no one knew where Kumanjayi Walker was or would be at 5 a.m. Julie Frost asked at the trial, if Felix had intelligence, it was fundamental that you find out what intelligence is. This is transcript 234. Frost, Felix had as much intelligence as I did. Question. So in other words, he didn't know, like you didn't know, where Kumanjayi Walker was. Answer. No one knew where he was. Question. So Felix couldn't advance the case any more than you could. Answer. Correct. Julie Frost. And the obvious starting point is where he's likely to be. Question. Answer, yes. This is page 239 of the trial transcript, 11th of February 2022. And you might have had a preference for a 5 a.m. arrest, but that's futile if you don't know where he's going to be at 5 a.m. That's correct. And so it makes sense, doesn't it? They would have asked you, well, where's he going to be at 5 a.m? And you say, look, I've got no idea. Answer, I'm sure they did ask me. Question. And you would have said, I've got no idea. Answer, that's correct. Question. Zachary Rolfe then told you, I suggest, in order to make a plan, they needed to gather intelligence. And since they had no intelligence, he and the other IRT members would go and introduce themselves to the community, get the lay of the land and attempt to gather intelligence before they could start to make any kind of plan. Answer, I don't recall, but yes. Later on, question, he suggested to you, I suggest that this approach should be adopted at Uwindham. Answer, we had intel again, the houses that he was likely to frequent. That's as much intel as we had. Question, of course, as you told us, you had no idea where he would be at any point in time. Answer, no one would have. Question, and so it makes sense, doesn't it, that the IRT members could be saying to you, in this case, Zachary Rolfe, we need to get intelligence, we need to find out where he is, and that's how we can frame what we do once we know that. Yes. And so it's most likely that a type of conversation would most likely to occur, most likely. I'm suggesting to you at this point in time you provided a map of Uwindham. They then depart at 7 o'clock. If truly this 5 a.m. plan with all of its detail was communicated to the IRT and in fact given them, two things loom large. Why would Frost send them out at 7 p.m? Secondly, on the very first page it says, Kumanjayi Walker to be apprehended under an arrest warrant, as the evidence is made clear. Neither Rebel nor Rolf knew that a warrant existed. So if in truth this plan had been given to them and they were taken through it, then yes, they might have known the greater detail. They did not. And when they leave the police station at 7 p.m, Shirley Frost, as she's repeated several times in evidence, if you come across him, arrest him absolutely. Narjar and their submissions, erroneously I suggest, say that Kirstenfeld on the CCTV accepted that he was given a copy of the operational order, and I think they reference transcript page 1320 or 1390 of this inquest. That was not his evidence. His evidence was, and he repeated it following committal, the first time he saw that plan, the operations order, was here in this very court, in that very box, when it was handed to him at committal. Those were his answers to this inquest. So, Your Honour, to suggest that there's been this big conspiracy by Rolf to lie because he knew he went too far come the 9th of November 2019, that he knew he disobeyed the orders of Sergeant Frost, that he knew he shouldn't have done that, ought to be rejected. On the topic of LFO, Your Honour, I've been criticised because our submissions say that LFO wasn't directed to stay back at the police station. In question to Sergeant Frost, Mr Edwardson put to her, LFO was directed to stay behind, and she said, no, he was part of the 5 a.m. arrest plan, to which the question was, whatever was in your plan, he was asked to stay behind. Alafeo said this at trial, and I cross-examined him again in this inquest, and he accepted it. All right. Now, you were specifically told, were you not, by Sergeant Frost that neither you, Smith or Han were to assist. You were to stay at the police station. Answer, that's correct. In other words, you were never told that you were to go out in the community with the IRT to assist in the arrest. Answer, that's correct. Question, you were told that you were to remain at the Uindamu police station and assist once he'd been arrested. Answer, that's correct. During part of the briefing that for it, if Mr Walker's to be arrested the next morning at 5 or 5:30 in the morning, she wanted me to accompany them. Bearing in mind, Frost said if you come across him, arrest him absolutely when they left at 7 o'clock. Question, sure, but I'm talking firstly about when they went out. You were told specifically that you were not to join them when they departed at 7 o'clock. Answer, that's correct. And the same applied to her, Han and Smith, that's correct. So all you were told was that if the arrest happened to occur the following morning, that on that occasion you might come on at that shift at 5 o'clock and you might go out and help them. That's correct. But in the meantime, your understanding was that they were leaving and deployed at 7:05. That's correct. They knew that 577 was the last known place he'd been seen at. That's correct. Police did not know exactly where he was to be located. That's right. They were to conduct intelligent gathering exercises to try and locate him if they could. That's correct. And if they came upon him, they were to arrest him. I believe so, and if they came upon him and arrest him and you were still on duty, you would then help with the others, facilitate the arrest process. Answer, if that happened to take place, then I'll assist them. And so you want to what counsel assisting today about tendency of text messages, that if Rolf was investigated earlier, if he didn't get accepted to the police force on the application, then ultimately Rolf and Kumanjayi Walker would never have crossed paths. Well, Your Honour, sure. But that's mere speculation and supposition. It's that day then reasoning. Of course, if Constable Rolf wasn't a police officer, he wouldn't have been with Kumanjayi Walker. But it's like saying if Constable Rolf wasn't born, he wouldn't have come across Kumanjayi Walker. It has no assistance to Your Honour's inquiry. So we say, Your Honour, Rolf has neither lied about knowledge of the 5 a.m. arrest plan, he's neither lied nor disobeyed that plan. Your Honour, what occurred afterwards, as we all know well, was that they came across him and arrested him absolutely. Your Honour, your counsel assisting said, in respect of this very significant issue that the parties make submissions on about it being a fabrication of Mr Rolf saying that Kumanjayi Walker reached for his Glock, your counsel assisting said this, that was not put to Barham at trial by defence or at committal. That's true, Your Honour. But Your Honour, our position at trial was, and it's in the transcript, you don't pause the body of the video. You don't analyse it frame by frame. You don't stop it, slow it down, rewind it. Your Honour, Matthew Sorrell, the evidence which is in your brief, there's limitations of body-worn video. It's on your chest, it sees out, it doesn't capture everything. Just because something doesn't feature on the body-worn video does not mean it did not happen. It would be improper reasoning to suggest just because you can't see it, it did not happen. And Your Honour, if it was so significant, as parties put to Mr Rolfe, that it was a fabrication or a lie, why didn't they take them to the body-worn video, which, as you know from our submissions, no one sought to play in this inquest, and ask Mr Rolfe to tell them at what point in time in the body-worn video, in the interaction, do you say that Kumanjayi Walker reached for your block? If it is such a significant issue, Your Honour, there's no point raining on the defence lawyers for not asking it. They should have asked it themselves. Your Honour, in respect of McDevitt, his expertise was not challenged. Some might say, experience in the Northern Territory, but Your Honour, he was the architect of the very use of force policy that the Northern Territory had in operation at the time. His inescapable opinion, and it features at page 3 of his report, and it's this, I quote, "Rolfe's actions were necessary, appropriate and proportionate to the threat. His actions were in accordance with the policy and training of Northern Territory Police Force." Your Honour, just because Sergeant Barham took a different view doesn't mean you ignore or put to one side the opinion of McDevitt. Your Honour might recall, having read the trial transcript of Detective Sergeant Barham, that he was played a video that he posted on his own social media of a police shooting where an assailant had a knife. His comments on the top of that video were, "brings a little bit of reality into the argument," or words to that effect. Your Honour, that's why we say Sergeant Barham was discredited, and you can't simply just ignore competing expert evidence, particularly when parties here are urging upon you to find 9th of November was excessive. Your Honour, what last bit I want to say about that before finalising, again, following this bouncing ball, the bouncing ball which will lead you to liability findings, the bouncing ball we say would lead you into error, is the submissions of parties that, Your Honour, make a recommendation that Section 148B of the Police Administration Act be repealed. It even started as you appeal acquit provisions in the code. You repeal double jeopardy. Your Honour, I go back to that question. For what purpose would those submissions possibly be put to you other than to suggest that Constable Rolfe committed an offence on the 9th of November? But Your Honour, you haven't broadened this inquiry into Section 148B, and if you did, Your Honour, it would have the true hallmarks of a Royal Commission. You haven't inquired as to how it came about, why it came about, the intentions behind it. It was left for a jury. It was a defence available to Mr Rolfe. And Your Honour, we know nothing about which basis the jury acquitted. And a mere abstract statement that is in effect it allows police to do whatever they want does not inform you. If Your Honour thought to take that on board and make any recommendations about that provision, in my respectful submission, you risk falling foul of the prohibition of Section 34 because that particular defence and the legal standard that applies to it, when all of these parties here, vast majority, are asking you to accept Rolfe used excessive force in all 3 shots, cut across the jury verdict, would have you reason that he was guilty of murder. And Your Honour, cannot countenance such a submission, and you ought not traverse that. Your Honour, this has never been about heroes and villains. As senior counsel said after the acquittal, and I'll say again, there are no winners. A young man lost his life, and another young man, that Zachary Rolfe, was charged with murder. Your Honour, it is truly a tragic circumstance. But let's set, or Your Honour should set, realistic expectations. Let's apply common sense. The authorities demand you must. Importantly, Your Honour should not be encouraged to go down a path that seriously risks undermining the jury verdict of acquittal or infringes, which would be a jurisdictional error, upon the prohibition of Section 34(3), making findings of fact as to excessive force, you can't. As to state of mind, you can't. As to whether what Constable Rolfe did on prior use of force occasions, and most important on the 9th of November 2019, was justified or otherwise, you simply cannot do it. Right? You're in a retrospective jurisdiction. It's too easy to get caught up in hindsight, to get caught up in the minute criticisms in this leisurely atmosphere as a courtroom, which I quoted from McIntosh and Webster. But Your Honour, there are constraints under your Act about what you can do and what you must not do. And Your Honour need to approach those constraints carefully so you do not fall into error. Your Honour, those are my submissions.
Thank you, Mr Officer. We are going to adjourn till tomorrow. Are we commencing at 9:30 or 10?
I think we can safely do 10. Can I just confirm that all parties are going to be here or will have an opportunity to be here? I do have submissions in reply, Your Honour. I don't think that I will be longer than 15 or 20 minutes, but I will have submissions in reply, and I don't want anybody complaining afterwards that they haven't had an opportunity to listen to them. So if arrangements need to be made,
Sure.
we can do.
Will we normally make arrangements to link people in who?
Yes.
And it's also being live streamed.
True, and we can provide transcript afterwards as well.
Your Honour, I had a note passed to you that I am departing back to Darwin tonight because I'm still awaiting a jury verdict. If I can be excused for tomorrow.
Sure, but of course, if you want to Teams link in or
Grateful, Your Honour. Thank you.
make any other arrangements for links, we'll accommodate that, Mr Officer.
Thank you, Your Honour.
Thank you. We'll adjourn now and we'll resume at 10 o'clock.
Stand. The Coroner's Court of the Northern Territory is now adjourned.